Contributions, an online presentation of the FEC's Information Division. This presentation, which supplements our contributions brochure, will define the term contribution, review the amount limitations that apply to contributions, and identify sources prohibited from making contributions. The Federal Election Campaign Act and FEC regulations define the term contribution very broadly to include anything of value given for the purpose of influencing a federal election. Examples include monetary donations, the provision of goods or services at less than the normal charge, and certain election-related communications made in coordination with a candidate or party committee. Regardless of the type, all contributions are subject to the limits set forth in this chart. Donors are listed in the left column and recipients across the top. The highlighted limits are adjusted for inflation each election cycle, so they will increase over time. In looking at the contributions chart, you'll notice there are two sets of limits for PACs, one for multi-candidate committees and the other for those that are not. As you can see, multi-candidate committees may contribute more to candidates but less to party committees. To qualify as a multi-candidate PAC, a committee must satisfy three criteria. First, it must have been registered with the FEC for at least 6 months. Second, it must have received contributions from more than 50 contributors. And third, it must have made contributions to at least 5 candidates for federal office. Once a PAC satisfies these criteria, the committee, and any PACs affiliated with it, may contribute up to $5,000 per election to a federal candidate. It's important to understand that contributions to candidates are limited on a per-election basis, with the primary and general elections counted separately. As such, an individual may contribute up to $2,900 to a candidate for his or her primary race, and another $2,900 for the general election. If the donor does not designate which election limit a contribution should count against, it's presumed to be for the next election in which the candidate will participate. Let's look at an example involving the John Doe for Congress Committee. The candidate's primary will be held on April 16th. A few days after the primary, John's campaign receives this check in the mail. The check is not designated and is dated April 15th, the day before the primary. Does that mean this contribution should count against the donor's primary election limit, or should it count toward the general since the campaign received the check after the primary? Actually, neither of those dates apply. For undesignated contributions sent by mail, the postmark is used to determine when the contribution was made and thus what election it counts toward. In this case, the postmark date is before the primary, so this would be a primary contribution. The campaign should retain this envelope as part of its records. The contribution check is in the amount of $5,800, double the per-election limit for individuals, and is signed by one person. On its face, this is an excessive contribution for the primary election. At this point, the campaign has 3 options for dealing with the excessive portion of the contribution. It can refund it, reattribute it to another donor if applicable, or redesignate it for another election. The check appears to be drawn on a joint account, so reattributing the excessive portion to another account holder may be an option. In this case, FEC regulations permit the committee to presumptively reattribute the excessive amount without seeking permission from the donors in advance. The committee should attribute the permissible amount to the individual who signed the check, then reattribute the excessive amount to the other account holder. The committee must inform the donors of the reattribution and offer them the option of receiving a refund instead. Committees must also be careful to ensure that their presumptive reattribution does not cause a donor to exceed a contribution limit. Alternatively, the campaign may redesignate the excessive portion of the contribution to the general election. Campaigns may presumptively redesignate contributions received from an individual or non-multi-candidate committee to another election within the same election cycle. If a multi-candidate committee makes an excessive contribution, the campaign must receive advance authorization to redesignate the excessive portion. In this case, we have an individual contribution, so the campaign may presumptively redesignate the excessive portion to the general election, but must notify the donor and offer the option of a refund. The best way to deal with excessive contributions is not to receive any. The FEC recommends that donors designate all contributions made to candidates up front, and that recipient committees obtain signatures for all joint contributions received. In some cases, donors must designate their contributions. If, for example, a donor wants to make a general election contribution before the primary, designation would be required. Also, if a donor wants to make a debt retirement contribution, subject to the limits for a past election, designation would again be required. We've talked about the limits on contributions and how they apply. Now let's look at some types of contributions that are flatly prohibited. The first is contributions from corporations and labor organizations. These entities have long been prohibited from using their treasury funds to make contributions in connection with federal elections. They are, however, permitted to establish federal PACs that their employees and members may use to make contributions. Federal government contractors are also barred from making federal contributions. However, individuals who work for a business that holds a government contract may make personal contributions. Persons who are not U.S. citizens or green card holders are also prohibited from making contributions. Domestic subsidiaries of foreign corporations have been permitted to establish PACs so long as foreign nationals do not participate. Finally, the law prohibits contributions in the name of another, essentially one person reimbursing another person for a contribution. Federal law also prohibits contributions from foreign nationals, national banks, and federally chartered corporations in connection with any U.S. election, federal, state, or local. That concludes our overview of the limitations and prohibitions on contributions. For additional information, please consult our contributions brochure, as well as the Federal Election Campaign Act and Commission regulations. The Federal Election Commission is committed to encouraging voluntary compliance with the federal campaign finance laws. In addition to the information we provide on our website, we maintain a toll-free information line you can call for help without having to identify yourself. We respond within 5 business days to questions sent by email, and we conduct conferences throughout the country, host webinars on a variety of topics, and post e-learning videos, like this one, on our website and YouTube channel. We encourage you to make use of these resources and look forward to serving you.